issue here today?
To simplify it for the public to understand, is last year the legislature wanted to remove the fundamental right to see what our legislatures were doing. They wanted to close doors and operate in the dark. They passed House Bill 477 that had absolutely zero validity other than to put them in darkness and hide their practices behind closed doors. The Supreme Court of the United States in Buckley versus Vallejo, and also including Citizens United, has unanimously upheld that campaign finance limits and disclosures are constitutional and the preferred or only means to prevent corruption, specifically pro-quid pro donations for large donors. What we're looking at here is very clearly the evidence shows in Utah that we have candidates and office holders that aren't just satisfied to put their money in their campaign account in one pocket that we can see. They started saying, well, we're going to have this pocket for me, and this pocket's going to be my PAC. For example, we didn't have a law that prohibited personal use donations of campaigns. They could pay their kid $10,000 to do a website that never happened. That's happened in Utah. We could see it in their campaign account. That got a little unnerving. So then we moved it to a PAC. We don't know, we can't see that. It doesn't have the same filing disclosures. They still kind of got in trouble. Your media are pretty good at doing that, but you can't find it during the primary convention. It is until August 31st you can see what's going on in PAC if you can identify it. Then what they did is starting in was what's called DBAs, doing business ads. For example, Mark Shurtleff has a DBA called Guided Strategies that belongs to Jason Powers as campaign manager. So in 2008, instead of paying his kid $10,000 or $20,000 for this and buying the new Jaguar, which we could find even if it was in his PAC, he did a lump sum to DBA. And by doing that lump sum, by paying huge credit card receipts, citizens lose the right to find out specifically any donor over $50, specifically any expenditure over $50. Utah law is very clear because as an elected official, you have very acute responsibilities. You lose some certain rights or freedom of speech, if you will, because you're under a microscope. The law currently reads that even if the candidate was unaware it was illegal, unaware that it happened, if he or any member of his campaign staff violated any provisions, a single dollar amount, they're ousted from office. They lose the annulments of office. And that's under civil. If it goes to criminal, they also lose the right to vote.
So tell me this, are you saying you're not pleased with how he is showing his campaign money? Is that, I mean, you're just not satisfied with how he's...
What I'm saying is the top elected officials of the state of Utah are charged with enforcing election law, not violating it. And in fact, the Lieutenant Governor in 2009, Van Herbert, told Wimmer, and he closed, and you can go find his 2009 year end, he closed his campaign account, which took 5 filings. The reason? To consolidate campaign accounts to his PAC, which only has 3 filings. What I'm not happy with is no one wants to discuss the issues on the merits. It's very clear they're in violation of the election code, that civil and criminal prosecutions could happen, and their only way to deal with it is evade. If we put those self-authenticating documents down from Governor Gary Herbert, which is his declaration of candidacy signed by him and Governor Bell, and we take maybe, for instance, his 2010 primary filing, him and Governor Bell on the campaign account. But then August 31st, we look into his FOG PAC, Friends of Gary Herbert, and FOG's appropriate because it's fogging where the money's coming from. We find expenditures and contributions for his campaign, paying for campaign staff, paying for office staff, paying for office in-kind contributions that we were never able as a citizen that had the right to see it during those proceedings to make an informed choice. You don't have a right to vote unless you have the information to make that determination.
Okay, so you're saying the violation was that they didn't make it available for the citizens to be able to see this. That is where they violated the law.
Absolutely. And in Utah, if we allow unlimited campaign contributions, why do we need to hide it? Why do we need to launder it through DBAs and different PACs? The only reason is it's no different than Chicago. Money laundering, crime, fraud, corruption. It's happening right here in the state of Utah, right under our nose, and any one of you can go right to the Lieutenant Governor's website, elections, and find it for yourselves.
So tell us too then, so as they said, because they did this, they violated this law, allegedly, they should be ousted. Would that put you in the position of governor or lieutenant governor?
You know, I think it's very important to qualify whether or not that's my intent. That's a possibility the way that the code reads. But I, as one of the sponsors of the Anti-Bribery and Anti-Corruption Initiative, have probably done more research on campaign laws and disclosures than even the media in the state of Utah. What I found in preparing for that is specifically the Attorney General started out with a campaign account. Then he had a PAC account. Then he had a PAC account with DBAs. Then he had multiple PAC accounts, multiple campaign accounts, to the point you're never going to find out who's donating to him. And let me just bring this further. I need to bring this further. The anti-bribery and anti-corruption were designed to be the first referendums using e-signatures. We couldn't get enough signatures on that because the public just lost interest. 97% of the people agree that needs to happen. So we looked at the easiest way to prove the e-signatures was ballot access. Farley Anderson agreed to be the guinea pig and go out and get those 1,000 signatures, including e-signatures, to be the test case, and he was an Anderson v. Bell. Then he came to me and said, Mr. Maxfield, you got me into this mess. You're going to be my running mate. And I fought like hell because I think anybody who voluntarily runs for office needs their head examined. For whatever reason, they need their head examined. But I did, for one thing, to be a man of my word to support him. Now that put us in a different situation where instead of just 20A1703, we can file a verified petition as a registered voter, is we're now a candidate. That had a proceeding under 20A1402, I believe, that required an immediate hearing. In fact, when that was finally dismissed, Judge Reese said, you brought valid points. If this hearing would have been held before, I could have ordered the Lieutenant Governor to remove their names from the ballot. If it would have happened before the canvass, I could have ordered them not to be counted. But since we've drug our feet and this is 7 months past the time it's supposed to be heard, I don't know what to say. I'm sorry. So my primary focus is not as a candidate. My primary focus here is as a registered voter. I'm mad as hell when we have elected officials that only responsibility is to protect my right as a voter. Free and fair elections with free and open reporting of all campaign contributions and donations. Somehow here in the state of Utah, and I quote Governor Gary Herbert, that says he believes that campaign contribution limits violates constitutional free speech. Every court that has addressed that has disagreed with Governor Herbert. The same statement that can be made is we believe that because we're in Utah, we have superior moral fiber, that large campaign contributions don't sway the public. Alton Cole, to give you an example, you might remember this one. Jeremy Johnson Iworks donated over $200,000 to the AG. In my first complaint against the AG, verified petition, I filed that in February 2010 as a possible illegal campaign contribution because out of the 8 corporations, most of them didn't exist. Most of them were on file for the Lieutenant Governor's office, besides the other problems. What I'm telling you is what we have in Utah, there is no honesty in campaigns as far as where the money's coming from. And if we are of a higher moral fabric, why do we have to bury that under PACs and DBAs and other things removing the public's right to know?
Good. I wish I could ask more questions. Very well said. I'm sure others would like to know. I have a new desk.